Over the past 50 years, the understanding of students' rights in American public schools and the legal boundaries of those rights have shifted dramatically. Now, before the 1970s, courts largely viewed teachers and administrators as in loco parentis, and this is Latin for acting in place of parents. Now, under this framework, school officials had a broad authority to decide what forms of speech, expression, and privacy were appropriate for the students in their care. Students, in turn, were expected to follow the school rules as much as they would comply with the expectations set forth by their own families. In 1969, however, the case of Tinker versus Des Moines Independent Community School District would change this framework, as the Supreme Court would go on to declare that students did not lose their constitutional rights to freedom of speech upon entering a public school facility. So let us highlight some of the key constitutional amendments and legal protection they afford students. The First Amendment protects their ability to express their opinions and practice their beliefs as long as it does not disrupt learning. At the same time, the Fourth Amendment guards their privacy by requiring schools to have good reasons before searching their belongings. The 14th Amendment ensures that students are treated fairly and equally, especially in discipline and access to opportunities. Together, these protections help to create a school environment where students can learn and express themselves and feel safe. Students do have constitutional rights, but how those rights apply depends on the type of school they attend. Public schools are government run, so the Constitution fully applies. Students have right to free speech, privacy, and due process, although schools can set reasonable limits to keep the learning environment safe. Charter schools are usually treated like public schools, so most constitutional protections apply there as well. Private schools, however, are not government actors, so the Constitution does not directly apply. Instead, students' rights comes from school policies, handbooks, and enrollments agreements, along with federal laws if the school receives government funding. For virtual schools, the same rules apply. If the program is publicly funded, then the constitutional rights apply. If it is private, then the rights are governed by contracts and school policies rather than by the Constitution. The First Amendment and students' off-campus social media expression is emerging as one of the most contested issues in modern education law. Now, many students today express themselves on social media platforms, posting opinions about school policies, teachers, sports teams, and social issues. Now, sometimes schools discipline students for those off-campus posts, prompting questions about whether the school can limit speech that occurs outside school grounds and outside school hours. This issue has been debated in the courts and in school districts nationwide, especially after the Supreme Court's decision in Mahanoy Area School District versus BL in 2021, which held that schools have limited authority to regulate off-campus speech, but can sometimes discipline it if it causes a substantial disruption to learning and school activities. Now, on one side of the aisle, argument supports that schools should be able to discipline students for harmful off-campus speech, as it protects school safety and learning. Now, online speech can directly impact school environment. Incidents such as cyberbullying, threats, and harassment left unchecked can disrupt learning. Many instances of off-campus speech are targeted attacks or harassments of other students, which can affect victims' safety and their overall mental health. Now, since students engage in the consistent use of digital platforms, the distinction between on-campus and off-campus is less relevant because harmful speech can spread quickly, as we will see in a case we're examining later. Though the speech may have been initiated off-campus, it can still have a negative influence on school dynamics. Cyber harassment and cyberbullying and true threats are serious harm that falls outside of the First Amendment's protections, so the public schools do and should retain the authority to address them. On the other side of the aisle, key arguments supporting students' free speech rights being protected off campus include levying the First Amendment protections. Now, as stipulated by the court, students do not lose their constitutional rights simply because they are students. Speech that occurs off school property should generally be protected from school punishment. Limits to school authority. If schools can discipline every unpopular opinion voiced online, then student speech may be chilled and their creativity or civic engagement stifled. Distinction between harm and expression. Not all controversial or offensive speech actually causes disruption. Schools should focus on real evidence based disruptions, not speech they simply dislike. The First Amendment inhibits public school officials from censoring students' expression made beyond the school environment simply because it contains language they find offensive or language that is misaligned with their interpretations of community values. Now, Leroy versus Livingston Manor Central School District 2025 is a significant recent case addressing the scope of students' First Amendment rights in the context of off-campus social media speech. The basis of this case was Leroy's posting of an image depicting a friend kneeling on his neck with the caption, "Cops got another one." Now, this led to strong reactions from the community, as student protests and school investigation. The court's ruling reinforced the limitations that schools have over campus social media speech, reinforcing the Supreme Court's guidance in Mahanoy versus BL. From an educational leadership perspective, I support students' off-campus speech as it is both legally required and ethically sound. Now, legally, the First Amendment cases such as Mahanoy and Leroy makes it clear that schools cannot discipline students for off-campus expression unless it constitutes a true threat, targeted harassment, or a substantial disruption. Respecting these limits is essential to upholding students' constitutional rights. Now, ethically, agreeing with this standard reflects my duty to ensure fairness, prevent misuse of disciplinary authority, and to model respect for democratic principles. When schools overreach and react inappropriately to these incidences, it conveys to young people that their voices are insignificant and that they should remain silent unless their views align with those in authority. Protecting lawful student expression, even when it is unpopular or uncomfortable, reinforces a school culture grounded in equity, integrity, and respect for individual dignity.